Could you please introduce yourself to the court, spelling out your last name for the record?
Certainly. My name is Dr. Kendall Oxman. That's O-X-M-A-N.
And what is your current occupation?
I'm currently a professor of child psychology at the University of Hawaii, but I also work as a toy consultant throughout the United States.
And could you tell the court a little bit about your educational background?
Absolutely. I received my bachelor's in psychology from the University of Virginia. I then went on to receive my MA and PhD in psychology and human behavior from the University of California. My educational background is located in my CV with other credentials.
May the record reflect that I'm showing opposing counsel what has been previously marked Plaintiff Exhibit D for identification purposes.
No objections, Your Honor.
Let the record reflect that I'm showing the witness that same document. Dr. Oxman, could you please identify this document for the court?
Yes, this is my CV. It's a resume, basically.
And does it appear to be fair and accurate?
Yes, ma'am.
Authored by yourself?
Of course.
At this time, we offer Plaintiff Exhibit D into evidence.
Any objection, Mr. Blano?
Without objection, Your Honor.
It's in. Thank you.
Now, Dr. Oxman, you just mentioned that you're a toy consultant. Exactly what does that mean?
Essentially, that means that toy companies will hire me to evaluate their toys in terms of marketing as well as risk assessments.
And do you have any qualifications that aid you in this consulting?
Absolutely. I've been published and I've studied the topic of the mouthing behaviors of children for numerous of years. And with this, I'm able to draw conclusions on the safety of different toys and the likelihood of a toy being mouthed.
And what methods do you use?
I use something I like to call in my classrooms the 3 A's of product evaluation. That is that I analyze, assess, and ultimately advise on the toy to my client.
And is this reasonably relied upon in your field?
Absolutely.
And does this provide sufficient data informing conclusions?
Yes, of course.
Now, I'd like to walk through that. You mentioned that your first stage is the analysis stage. What do you typically analyze?
This is where I review relevant documentation, the toy in question, marketing structures, as well as the packaging labels. Specifically in today's case, I reviewed 5 affidavits. One was Sam Bauer, a neighbor of the Davis family, Miss Andy Davis, Mr. Brett Miller, the babysitter who was taking care of him on August 8, 2009, Dr. Chase Tuckman, the clinical toxicologist who was attending Joey during his final hours, and Quinn Brown, who was the toy designer of the Princess Toys.
And were these sufficient in forming a conclusion today?
Absolutely, yes they were.
Now, I'd like to talk about your assessment phase. Could you please explain that to the court?
It's during my assessment stage that I make my conclusions based off all of my documents and what I've reviewed. Specifically in today's case, I made 2 significant conclusions based on the Princess Beads.
And what was your first conclusion?
Well, my first conclusion was that the scenario concerning Joey Davis and the Princess Beads was highly unusual and unlikely, even unforeseeable to a child psychologist like myself.
And what made the scenario unlikely?
Well, first, Happy Land used a very standard chemical known as denatonium on the toy. Studies have shown that any child that tries to mouth a toy coated in denatonium will actually spit the toy out immediately, and they won't try to mouth on it again. This is because denatonium creates a bitter taste instantly upon putting the toy in your mouth.
And were you able to form any other conclusions in today's case?
Yes, also based on the foreseeability, the use of warning labels by Happy Land Toy Company. I believe that they adequately warn consumers and parents and caregivers on exactly who should be playing with the toy and how they should be playing with the toy.
And were there any other assessments that you made?
Yes, the second one would be based on the supervision on the part of Miss Andy Davis and Mr. Brett Miller, who was taking care of Joey that day.
And exactly how is supervision related to child psychology?
Well, supervision plays a crucial part in understanding mouthing, and mouthing, by the way, is simply teething. That's what we normally refer to it as when a child puts something in its mouth. And supervision plays a vital role in understanding that because studies have shown that a child is 40% more likely to participate in unsanctioned mouthing when they're left alone, which is specifically important in today's case as Joey was left alone.
And what type of documents did you rely on to form a conclusion about supervision?
Well, specifically, I reviewed the affidavit of Miss Andy Davis, Miss Brett Miller, and of course, the warning labels.
And were these sufficient?
Yes, ma'am.
And you mentioned that you reviewed the warning labels. How are warning labels related to supervision?
Well, warning labels are used, and we advise companies to put them on their products to warn consumers and parents on exactly what the product is like, who should be playing with the product, the audience, and that sort of thing.
And could you please explain for the court the warning labels in today's case?
Absolutely, I've actually prepared a demonstrative of the warning labels to help explain my testimony.
At this time, Your Honor, I ask that my witness may step down and make use of a demonstrative.
Certainly.
Exactly what is the jury looking at?
This is just a blown-up version of the packaging labels of the Princess beads.
And could you explain the warning labels on this box?
Yes, there are very clear age restrictions on the front and the back of the box, specifically that this is for ages 9 and up. And there are also even clear age restrictions that any child under the age of 3 shouldn't even come into contact with this toy. Now, this is especially prudent in today's case as Joey was 2 years of age.
And are there any other warning labels on this box?
Yes, also on the bottom of the box, there are more specific warning labels about the actual product. Specifically that, of course, there is a choking hazard. Anytime you're dealing with small objects, there will be a choking hazard, or the potential thereof. Also that it's not for consumption, and that if it is consumed, that it may be toxic. I found that this, coupled with the age restrictions, adequately warned consumers and parents on exactly what they were buying when they purchased the toy.
And after reviewing documents, to your knowledge, did Andy Davis understand these warning labels?
Absolutely.
Objection, Your Honor. Improper opinion
How's it improper?
as to what he knew of Ms. Davis's understanding of the warning labels.
Your Honor, I believe that you just stated that he reviewed the affidavit, and in that affidavit it contains information that Andy Davis understood these warning labels. As an expert, he can rely on these affidavits to form that conclusion.
His expertise is in what field?
His expertise is in child psychology and toy consulting. So that includes supervision as well as in regards to toys.
As a psychologist, would he be permitted to give what he thought might be a reasonable response or a reasonable thought, or what the reasonable consumer might think?
Well, Your Honor, if he was to testify as to what Ms. Davis's state of mind was when dealing with the warning labels, that would be allowing him to speculate in this case.
So he can't testify to what Mr. Davis thought. Do you concede that he would be able to testify as to what a reasonable consumer might or should or most probably would think?
Yes, in that case, I would agree if it was more of a generalized opinion, but
Then I'll sustain your objection to that extent. His testimony's got to be limited to what he and his field of psychology would think that a reasonable consumer
Yes, Your Honor.
should think, might think, most probably would think, however you wish to phrase that, Ms. Bracey.
Do you believe that these warning labels adequately warn parents and caregivers about the risk posed by this product?
Absolutely, I believe that they adequately warn that any child under the age of 3 shouldn't even come in contact with the toy, and any children below the age of 9 should be playing with the toy. For example, if you saw a child age 2 playing with the toy, you should immediately move it out of its reach. And that's what these warning labels properly warn against.
Thank you, Dr. Axe. Were you able to form any other conclusions regarding supervision in today's case?
Yes, I actually broke this into 2 different parties. One was Miss Andy Davis, the parent, and the other was Mr. Brett Miller, who was taking care of Joey.
Now, I'd like to begin by discussing Andy Davis. What was your conclusion regarding Andy Davis's supervision?
Well, specifically with Miss Andy Davis, I learned that she, on numerous occasions, saw Joey playing with the beads, saw his fascination with the beads, and actually saw him try to mouth the beads on a couple of occasions. And yet, Miss Andy Davis always left the beads within Joey's reach. Now, I do have to commend her on observing his play with the beads and disciplining him, telling him not to play with them, but we have to understand that children age of 2 are not going to understand what's right and wrong. Simply telling them not to play with it isn't enough. We must leave them in safe environments, and unfortunately, he wasn't left in a safe environment.
Now, you also mentioned that you formed a conclusion about Brett Miller, the caretaker, on August 8, 2009. What was that conclusion?
Well, again, I learned that she, on numerous occasions, saw Joey's fascination with the beads, saw him try to mouth the beads as well. But more specifically, on August 8th, the day that Joey passed away, Miss Miller actually walked out of the room, out of the living room, leaving Joey alone with those beads. And like I said before, as soon as a child is left alone, he's 40% more likely to try to mouth on those beads. And this increases with every single minute.
Wanted to peacock